proceedings, and the end of the day is that either the suspect are proven to be guilty or they're proven to be innocent. That is now what is not in the hand of SSBC, but it is in the hand of the presiding over judges. With that, viewers, we will be saying in a few while, we are expecting to see the arrival of the three panel of judges. As I've said in the beginning, the panel of judges, of course, they are represented by Justice, that is Dr. James Alala, who happened to be the one presiding over this event. And we have some of his justice, or some of the juries who are supporting him, Justice Stephen Simon, and then we have Justice Isaac Pur-Majok. Then we have four members of council generals in the Ministry of Justice and Constitutional Affairs. We have 7 advocates who are representing the prosecution panel, led by Advocate Deng Achwil Adija, and then we have also 2 investigators from the prosecution side. Then don't forget we have also 6 team representing the advocates who are on the defense side. These are 6, headed by none other than Dr. Gary Raimondo. And today, of course, they will be sitting together and hear the reply, because we said yesterday there was a reply that is written, submitted to the jury, to the presiding over judge, and also copy was given to the defense team. This alone, it is on the establishment of the special court. As we speak, we have not yet opened the case. The cases level against the 8 accused has not yet been opened. But few minutes from now, as soon as the court or the presiding over judges now accept all the claims that are being raised or put across by the 2 sides, then the process can kick up immediately. Viewers, I will connect you back to my colleague at Freedom Hall, and let's see if the panel of the judiciary or the judges arrived, then we can start. Stay tuned, continue to watch us. As we said, we're live on YouTube, we're live on Facebook. Just log in SSBC Official and you get us streaming live. Let's connect to our colleague at Freedom Hall. As you could see, the suspected individuals are already at the courtroom, and the courtroom, of course, today is full, accessible to public, to members of public, provided that you adhere to the rules and regulations of the courtroom. You could see Freedom Hall today is different from the first day. This alone, to those who are doubting, who are saying, no, the courtroom is not going to be fair, it's not going to be... Now you could see by yourself. It is live, and nobody does any editing on the live coverage. So let's connect to my colleague. We have down on the courtroom, we have my colleague, Matiang Joseph, we have Mori, and we have also Leila Osman, and we have Martin Justin Kose. These are some of the SSBC crew who are covering from there. Let's get to them and hear more.
Loud and the public as well. So long that if you are South Sudanese having the nationality, you can move to the court premises to take part in the proceedings. These were the words stated by the presiding judges yesterday during the adjournment of the proceedings until today. The proceedings are still at the early stages. Defense team and prosecution team is still arguing how the court should proceed. The bigger point here is immunity. The defense argued that the first vice president cannot be prosecuted, but the prosecution counted that immunity applies only to president, not to other office holders. In their view, no political position should shield an individual from accountability. On the question of the revitalized peace agreement, the prosecution stresses that while a hybrid court is planned, national courts retain full competence to try serious crimes under domestic law. They framed these as both a matter of sovereignty and of justice not being delayed. So in summary, the prosecution's message is clear. The court has the power. The accused has no immunity. And the South Sudan, as sovereign nation, has got its laws, the law of the land, to try serious crime. So the court proceedings are expected to commence as the presiding judges arrive to their venue. From now, let me hand over the microphone to Leila Osman, the only lady among the men covering this live.
Yeah, thank you, Martin Joseph. Actually, it's not the only women. I think there are some female journalists from other media houses, so I'll need to correct. Murder and crimes against humanity in connection with an attack in Nasir in March 2025. Just a reminder again about the suspect that is Port Kang, aged 40, according to order. And then Mampal is aged 27. A businessman, and then Gatwish Lam, a member of parliament, aged 66 years, and Lieutenant General Gabriel Dwaplam, deputy chief of the SSPDF, and aged 53 years. Then followed by Dr.Riek Machar Teny, who is in fifth position in the according to the judgment procedures. The suspended first Vice President of the Republic of South Sudan, who is 73 years old. We have in number 6, Brigadier Camilo Gatmichael, Head of Administration and Finance, Transitional National Security Committee, aged 47. Then we have number 7, Madin Yakriak, a signal personnel radio operator, aged 45 years, followed by the 8th suspect, that is Dominic Gatkok Riak, a generator operator in the office of the suspended first Vice President, who is aged 57. Just maybe a reminder again about the charges. The charges are as a result of the March 2025 Nasir incident, where the White Army Militia overran a South Sudan People's Defense Forces SSPDF base. The attack resulted in over 250 deaths, including senior SSPDF officers. The government alleges the 8 accused are allies of the suspended first Vice President, Dr. Riek Machar Teny. For more update, as we've maybe in regard to what is happening in the courtroom is full actually compared to day 1 and 2, and the situation looks a little bit calm from observance within the hall. And I'll hand you over to my colleague Peter Mori to give you more updates.
Thank you so much, my colleague Leila Osman. I just need to give our listeners and viewers of SSBC a summary about the issue of immunity of the first Vice President. According to Article 103 concerning immunity, it says the President shall be immune from any legal proceedings and shall not be charged Supreme Court. The President shall be entitled to appear at the proceedings of the tribunal and to be represented by a lawyer or other expert or any other person of his or her choice. If the constitutional panel convicts the President, it shall communicate its final verdict to the Assembly, and he or she shall be deemed to have forfeited the office. If the notice for the removal of the President is on the grounds of mental infirmity or physical incapacity, it shall be based on a report submitted to the Assembly by a medical board consisting of qualified and eminent specialists from the Medical Commission in respect of the alleged infirmity or incapacity. Viewers, according to this article 103, there is nothing mentioned of the first vice president or the vice president. That means the only immune person from impeachment is His Excellency the President. And Article 104 says appointment and removal of the vice president. The vice president shall be appointed by the president, subject to approval by a two-thirds majority of all members of the National Legislative Assembly. The vice president may be removed by the president or by a decision passed by two-thirds majority of the members of the National Legislative Assembly. If the post of the vice president falls vacant for any reason, the president shall appoint a replacement. The vice president shall fulfill the conditions of eligibility for the office of the president as prescribed by this constitution. To assume office, the vice president shall take before the president the same oath taken by the president as prescribed by this constitution. So far, this is what Article 103 and Article 104 said about the vice president and immunity of the vice president and the president. With this, let me pass the mic to my colleague Martin Justin.
نعم أيها السادة والسيدات المتابعون الكرام في كل مكان، كما نلاحظ أن دستور الانتقال لجنوب السودان وحتى اتفاقية السلام المنشط لم يحمي كل من النائب الأول والنواب الآخرين من هذه ما يعرف بالمثول أمام المحاكمة. المحاكمة.
Thank you so much for joining us. Still, you're watching us live from Juba and live broadcast of the third session of the court proceedings of the suspected Port Control, among other 7 individuals who are from military and political background of the SPLM-IO. And these individuals, of course, the court is taking place is due to the 3rd of March incident that occurred in Nasir, which has actually culminated to the death of more than 250 SSPDF soldiers, plus the killing of Major General Majur, who happened to be killed, as well as one. So viewers, the presiding over juries or the presiding over judges are getting on the courtroom, and as you could see them marching or coming up, this alone will tell us that the process is starting, and let's continue to watch and see what will be the end or the outcome of today's gathering or today's court proceeding. Let's watch and back to Freedom Hall.
Please sit down. As usual, we start by taking the attendance of the parties. Maulana, you are welcome.
Attendance, please.
My Lords, Honorable Court, in the presence of Consul General Deng Ashwil Adia, in the presence of the investigator, the complainant, and the team of the prosecutions. Thank you.
بسم الله الرحمن الرحيم. الأستاذ كورلو الكور عن هيئة الدفاع وبحضور المتهمين من الأول حتى الثامن.
Honorable Court, we do have objection on the appearance of some advocate with the defense team who are not licensed, and this is a clear violation of the Advocate Act, Section 26, Sub 1, which read as follow: an advocate shall renew his or her license at the end of January every year. Failure to renew his or her license, the license shall be deemed to have been suspended until renewed. And these advocates are as follow: Advocate Deng John Deng and Advocate Wurnyang Kir Wurnyang. Therefore, the prosecution is requesting those advocates to be sent out of the defense team until they regularize their license status under the Advocate Act 2013, and we are hereby submitting the list of the Bar Council indicating advocates who are enrolled. So it is unfair to allow advocates who are not licensed to present the case. Thank you very much. Your Lordship.
Kir and who? Warang
Yeah,
Kir?
this is Wurnyang. Yes, this is the names. Yes, Advocate Deng John Deng. And Advocate Wurnyang Kir Wurnyang. And this is the list, Honorable Courts, and the application. This is the list. No, Alex. This is verbal. Thank you.
المحكمة الوقرة.
Excuse. You see, yesterday or the day before yesterday, like we agreed that whatever you are presenting, it should be in writing. So if it is written,
Yes, written we have.
you give us
Yes.
a copy.
Yes. The last paragraph.
Defense,
The last paragraph, yes, we have it.
the
And this
defense
is for the
copy.
defense. This is for the
And then
defense. The last paragraph of the objection. Yes. Go ahead. It is in the last page.
it's all right, it's okay. We will read it. It is written here. For the defense, you have also
We are ready مولاي. احنا جاهزين للرد على الطلب الذي تقدم به الإخوة في هيئة الاتهام. رغم أن هذه جلسة
excuse. Well, you also respond, but also it should be in nutshells, so that you get us the written form of your response.
مولاي
تفضل.
كله جاهز. الريتن فورم از ريدي. هنقدمه للمحكمة الموقرة باللغة الإنجليزية.
تفضل.
وفي النسخة الصورة منها باللغة العربية هنديوها للمحكمة، وبعد ذلك بنقدم الصورة باللغة الإنجليزية للمحكمة، لكن أنا هرد باللغة العربية على ما تقدم به الزملاء في الاتهام. بسم الله الرحمن الرحيم. اللهم أرنا الحق حقا وارزقنا اتباعه، وارنا الباطل باطلا وارزقنا اجتنابه، آمين. جمهورية جنوب السودان، السلطة القضائية لدى المحكمة الخاصة لحادثة الناصر جوبا 2025. الموضوع محاكمة المتهمين الدكتور رياك مشار تني النائب الأول لرئيس جمهورية السودان، جمهورية جنوب السودان، وسبع آخرون. القضية الجنائية رقم 15/33/2025 تحت أحكام المواد 48 50 52 61 62 64 65 66 67 70 71 72 75 76 على 206 239 من قانون العقوبات لدولة جنوب السودان لسنة 2008، والمواد 15 ألف وباء، والمادة 16 من قانون مكافحة غسيل الأموال وتمويل الإرهاب لسنة 2012 تعديل 2024. الموضوع رد الدفاع على اعتراض النائب العام بشأن ظهور المحامين المكلفين بالدفاع عن النائب الأول نائب الرئيس دكتور رياك مشار تني وآخرين. سعادة الرئيس وأعضاء المحاكمة وأعضاء المحكمة الموقرين، بعد واجب التقدير والاحترام التي تليق بمقام عدالتكم وبالإشارة إلى الموضوع على نلتمس شاكرين السماح لنا بالرد على اعتراض النائب العام بشأن ظهور بعض من زملائنا في الدفاع أن المتهمين الماثلين أمام المحكمة، وذلك على النحو الآتي: أولا، حق الدفاع وأصالة اختيار المحامي. سيد الرئيس، أن الحق في الدفاع حجر زاوية في منظومة العدالة الجنائية، وهو مكفول دستوريا وقانونيا ودوليا بموجب الأحكام التالية: واحد، المادة 19 الفقرة 7 والمادة 36 الفقرة 2 و 3 من الدستور الانتقالي لسنة 2011، والتي تنص على الآتي: لكل متهم الحق في الوقت الكافي لإعداد دفاعه والتواصل مع محاميه يختاره. المادة 184 من قانون الإجراءات الجنائية لسنة 2008 وتنص على الآتي: يحق للمتهم أن يمثل بمحامي للدفاع عنه. 3، المادة 14 3 ب من العهد الدولي الخاص بالحقوق المدنية والسياسية، وتفيد بأن لكل متهم الحق في محاكمة عادلة واختيار محاميه بحرية. وبناء على ما نصت إليه في المواد السابقة، فإن أي محاولة لتغيير هذا الحق تمثل انتهاكا صارخا للدستور والقانون الدولي. ثانيا، تعسف نقابة المحامين وانعكاسها على حق الدفاع. المتهمون اختاروا الأستاذ ورنيان كير والأستاذ دين جون للدفاع عنهم في إجراءات هذه الدعوة الماثلة أمامكم لما يتمتعان به من كفاءة على الرغم من استيفائهما شروط التجديد. رفضت النقابة تجديد بطاقاتهم دون مبرر قانوني، بما يمثل استعمالا تأسفيا للسلطة وعرقلة لحق الدفاع. 3، أن أحكام المادة 25 الفقرة 2 من قانون المحاماة لسنة 2013 أتاح لسيد نقيب المحامين منفردا سلطة منح المحامي إذنا خاصا للظهور في قضية محددة عند الطلب، وقد تم رفض الطلب دون مبرر قانوني. التناقض بين موقف النقابة الرسمي ودعمها المزعوم للمحاكمة العادلة وممارستها في الحرمان الفعلي من حق الدفاع يعكس إخلالا جوهريا بحق الدفاع. وأنا شخصيا اتصلت على نقيب المحامين قبل هذه المحاكمة اتصلت عليه وقلت له أنا قادم إليك لمناقشة هذا الموضوع، ولكن عندما ذهبت إليه فر بجلده وترك المكتب خاليا. ثالثا، أولوية حق الدفاع على القواعد الإجرائية. الحق في الدفاع لا يجوز تقييده بحجج إدارية أو تنظيمية مثل صلاحية البطاقة المهنية أو العضوية النقابية، وهذا ما أكده الفقيه الأستاذ الدكتور فتحي سرور أن الحق في الدفاع هو تاج العدالة الجنائية ولا يقيد ولا يساوم عليه. إننا في إجراءات هذه المحاكمة ومن واقع ممارسة مهنة المحاماة إننا لدينا إرث في دولة السودان. في دولة السودان عندما كنا جزء من تلك الدولة لن يحدث مثل هذه التصرفات. إن تأخر المحامي عن تجديد رخصته يتقدم بالطلب للنقابة لتجديد رخصته ويذكر الأسباب التي دعته للتأخير، يلزم بدفع غرامة رمزية ويسمح له بتجديد رخصته. ولكن ما بين ذاك الزمن وهذا يحدث مفارقات لا نعلم من أين أتى نقيب المحامين بهذه الممارسة التي لا تليق بمهنة المحاماة. بل أيضا أكدت ذلك صراحة اللجنة المعنية بحقوق الإنسان بالأمم المتحدة الحق في اختيار محامي بحرية جزء أساسي من المحاكمة العادلة. بل ونشير أيضا لسان جون برودو القانون الفرنسي، محكمة الاستئناف البريطانية، محكمة لاهاي، احترام اختيار المحامي عنصر أساسي لثقة المجتمع في العدالة ولا يجوز فرض تمثيل قانوني ضد رغبة المتهم. رابعا، الأهمية القانونية للمحامين المخولين. واحد، أن حجر الأساس الأول في الدفاع يمثل هؤلاء المحامين العمود الفقري في حماية الحقوق القانونية للمتهمين في القضايا الحساسة، وأن الساعد الأيمن للمتهمين تم اختياره بتفويض رسمي وممحور بتوقيع المتهمين مما يمنحهم الحق الكامل في الدفاع دون تقييد. على مدى السنوات الماضية وحتى الآن لم يكن هنالك من يجاهر بالدفاع عن المتهمين في القضايا الحساسة ضد الدولة إلا هؤلاء المحامين، مما يجعل العمود الفقري الأول في حماية الحقوق القانونية للمتهمين أن هذه المحكمة الجنائية الخاصة تتمتع بإجراءات استثنائية ويملك قضاتها السلطة المطلقة في اعتماد المحامين الذين يختارهم المتهمين، وهذا ما أكدته أحكام المادة 182 من قانون الإجراءات الجنائي لسنة 2008، والتي تنص يجوز لأي محامي مرخص له بصفة عامة بممارسة العمل أمام المحاكم الجنائية في جنوب السودان وأن يحضر يترافع في أي إجراء من الإجراءات الجنائية، كما يجوز لأي محكمة أن ترخص لأي شخص آخر بالعمل كمترافع أمامها. أن الذي يحدث للزملاء في الدفاع على حسب الادعاءات الذي تقدم به الإخوة في الاتهام نؤكد لهم بأن الذي يحدث هو عبارة عن ترسبات تلكم العملية الانتخابية التي جرت بدولة جنوب السودان والتي جرت بهذه القاعة، حيث كان الأستاذ دين جون الناطق الرسمي باسم مجموعة الإصلاح والازدهار، وكان الأستاذ وارنيان دائم لتلك الحملة الانتخابية، لذا أصر نقيب المحامين.
أستاذ سكور، نحن ما اتفقنا إنه نحن نديكم فرص
وبناء على ذلك
excuse please you listen. نحن اتفقنا على انه الناس اللي بيقدموا طلب يخشوا في نقاط ويقدموا طلبهم، وانتم لما تردوا تخشوا في نقاط وتقدموا طلبكم كتابة. الانزلاق للخطابات وضياع الوقت ما بفيدنا.
مولاي
نرجو excuse تركز واقتصر وجيب لي المكتوب بتاعك.
انا خلينا اكمل وبنسلمك المكتوب. وبناء على ذلك وبناء على تلك النص فإن المحكمة الموقرة السلطة الكاملة في منح الإذن للمحامين المذكورين للترافع دون الحاجة لموافقة نقابة المحامين، وأي اعتراض على ظهور المحامين المخولين يمثل انتهاكا مباشرا للحق الدستوري في الدفاع، بل وندفع عدم تجديد العضوية من النقابة لمن يحمل رخصة ممارسة المهنة غير جوهري ولا يؤثر على حقهم في الدفاع أمام المحكمة الخاصة، بل هي مجرد محاولة يائسة من الزملاء في الاتهام ولا يحمل أي قيمة جوهرية. خامسا، نلتمس من المحكمة الموقرة رفض الاعتراض المقدم من السيد المدعي العام بمنع ظهور المحامين لما يمثله ذلك من انتهاك للحق الدستوري والدولي في الدفاع، السماح للمحامين المكلفين من قبل المتهمين بترافع في هذه الدعوة، وشكرا.
شكرا. Give us the written copy.
المحكمة الموقرة ده صورة من الرد على الطلب الذي تقدم به الاتهام، وما هو طلب تفويض من المتهمين للمحامين الذين تم الاعتراض عليهم من قبل الاتهام. شكرا.
Honorable Court, the prosecution.
عندك تعقيب؟
I need تعقيب, yes.
تفضل.
Yes, the prosecution is very clear in their application, and we insist that it is the provision of the transitional constitutions of the Republic of South Sudan 2011 as amended, Article 136 sub 3, that advocacy shall be regulated by the law. And the law in question here is the Advocate Act of 2013, which is very clear under the cited section, which is talking about the advocate shall be licensed. This is number one. Number two, the decision to license the advocates are the decision of the Bar Council, according to the law, not the decision of the court. And the said advocate would have been, or they're supposed to contest the alleged decision that they said they were rejected not to be licensed. Maybe they are not fulfill the requirement for being licensed as an advocate. All the cited jurisprudence are not relevant, are not binding to the court, and the court should abide by the Constitution and by the law. And the section 182 of the Code of Criminal Procedure that have been cited is require a licensed advocate. Advocate who is not complying with the law should not be allowed to defend the accused persons. If the accused fail to find any suitable advocate, the law gives the government right to find who will be defend the accused as a legal aid. So the prosecution is insisting and requesting the court to send those advocates outside of the defense and to be seated with the public outside. Thank you very much.
Do you have written response?
This is our response.
It is verbal?
Yes, verbal, yes.
That's all right.
Yes.
Thank you.
According to the constitution and the law.
Okay, you're welcome. Sit down.
Yes, thank you.
Your Lordship.
Excuse.
Thank you.
You finished. You see, it was the view of this court to conduct these trials on daily basis. But we realized that this is not giving time or chance to the parties to prepare and to properly prepare for the next session. Number two, the court also to have time to easily look into long written pleadings by the parties. Number three, the public at large is to be given chance to exercise its works normally, for we recognized the role of the security forces in controlling the situation, and that is good. But also there is need to consider the need of the citizens to go to their work without being disturbed. For example, the institution like the university and other nearby businesses. It is this balance of interests. The court decided to defer this section to the coming Monday on the 29th September 2025 at 9:30 a.m. for the decision on the objection presented by the defense team and the objections that's presented by the prosecution now.
Your Lordship.
Therefore, the court is adjourned for that time. Thank you.
Go!
also raised concern about the daily activities of the public. So, given more
well as